much. Thank you. Good morning, everybody. I hope you're all, well, we will hope you're all okay, and all your family and everything are okay, and everyone is okay. Louise and I are kind of new to this Zoom teaching, like I think a lot of people are. We've already said to Emanuele, we've had some problems with Zoom connection. So if at any chance Louise and I do go offline, we will immediately get ourselves back on. So don't panic if suddenly one of us disappears or we both disappear. We will be back at some point. So, so don't worry. Lou, do you want to pop yourself in here?
The same thing. Good morning to everybody. Welcome to my kitchen. It's very, very strange. I'm a blackboard and whiteboard and pen teacher. So yes, very new to me too, but we have the material, you have a lesson. We're happy that it's reduced to 4 hours instead of 8, because 8 hours online is a little deadly. But apart from that, welcome to everybody. It's nice to see some of your faces, yeah, and some of your names.
Yeah, I can see some of you, especially the new people, or the people that we don't see, because you're all in different cities. So it's nice to maybe put names to faces. If you have bad connection or you can't hear, just write on the chat and we'll obviously answer anything. Might not be, let's say, in tempo reale, but we'll try to catch up with anything. Obviously,
also any questions as well, probably on the chat. It's better writing questions, and also if you have any doubts with spelling of answers, we will write the answers on the chat. Okay.
And also, because there's quite a lot of you, if you do need to ask something, you should have a little kind of hands up sign or something on your reaction screen or something. Just put your hand up and ask. Because there's quite a lot of you, don't all speak at the same time as well, because for us it becomes a little bit confusing, and also for the others listening, it gets there's quite a lot of feedback and echo as well. Are we happy with that, Lou? I think we are.
Absolutely, yeah.
Okay. Right. Does anybody have any questions before we start?
Okay. You do have a little test from us this morning, which we are suggesting should take a maximum of 30 minutes.
Yeah. It's the one that says midterm test on it. Okay. It's basically what we've done is we've taken some exercises from the last module that we did. So it's all about employment law, and some of it is contract law as well. I think so. It is 9:40. Louise, 30 minutes is? You're better at maths than me. Work it out.
On the group.
Okay, perfect. Right, so if you're all ready to start, then start the test. Obviously, if you finish before 10:10, that's even better. Okay, are there any questions from anybody?
Which page?
Where it says midterm test, you should have the pages. It says midterm test. Can you see?
Yes, I see, but I didn't print it, just this part, because I thought it was the demo page. Okay, I'm looking for.
Okay, there should be, there are 4 pages for the test, okay? Okay, so.
No, Manuela, don't panic, not 47 pages, no.
Yes, but which page?
Okay, sorry.
Okay.
I thought that were 47 page in half an hour, so I was like,
no.
No, it's fine, it's okay. I was just asking. I thought that test was like through the 47 pages. Okay, it's fine.
And This test is 4 pages, and you also have probably too much material today because originally we prepared for an 8-hour lesson.
I'm just writing that on the group.
Too much material. Okay, your first page should start with the example. I'll write it on the chat.
So I'm just writing.
La pagina è difficile.
It starts with an example that says the telephone company employs thousands of staffs, with staff being a mistake because staff is uncountable. So in the first
but
exercise,
the page number.
Okay, so the page number is page 1 of the midterm test. If you look at my screen, you'll be able to see which one it is. Okay, can you see?
Sorry, the problem is that in PDF scans, page 1 is like the 5th one. You know, they are like have been scanned like in the opposite way. So the first page is the 4th one. So it's 4, 3, 2, 1. Just this.
Okay.
It's just this. So the page you are referring to is like the 4th one in the PDF of the middle. It's just this one.
Okay.
So maybe.
Emanuele, is there anything we can do to sort that?
If you want, I can screen share for a moment the file, and you can, with your microphone, tell everyone when the correct page is on the screen so that everyone can follow through the PDF, just to make sure.
Okay, thanks.
Okay, yeah.
So I'm going to share now what I have as the... So you should see at the moment, this is the PDF file. Okay.
Right, hold on.
So this is the first page that everyone has on their PDF.
Yeah.
I'm gonna scroll down. This is the first page that we have.
Okay. Yeah. Okay.
So I'm going down. This is the the third page of the PDF. This is the 4th page of the PDF.
Okay, in fact, it's backwards.
It's gone backwards. Yeah. Okay.
So
that's fine. That's fine. We'll correct the text. We'll correct the test from page 4 to page 1. That's fine.
Yeah, that's absolutely fine. Yeah. No, that's fine. That's fine.
So from what page of the PDF should everyone start?
So
this one that is on the screen now.
Okay.
What's on the screen now, where it says exercise 1 there?
Okay. So the test is from page 5.
That's the first exercise.
Okay. So from page 5 of the PDF to...
Okay.
Oh, so it starts again. Okay.
That's a bit confusing.
No. What is the law of tort? No.
No, that's the actual lesson.
Okay.
No, they are just the 5 pages, the first 5 pages of the PDF. You have just to switch the order of the PDF.
Yeah, that one.
Yeah.
Okay.
So this one is the first page, which is the 5th for us.
Exactly.
Okay.
Then we have the second page. That's the 4th for us.
Okay.
Yeah.
So it's backwards.
It's backwards, yeah. Okay, that's fine.
It's not important in what order the test is done. It's not important.
Yeah, as long as it's... Yeah.
The instructions should be self-explanatory, but if you don't understand what to do...
Okay.
Emanuele, Mariangela is saying she's missing a page.
Okay, let me just check on the chat. Okay. So, so everyone should have the same file that was uploaded in the reserved area. So the test is, if I understood correctly, is from page 2 of the PDF to page 5. It's just that it goes backwards. So we should start, we can start from page 2 and go on to page 5.
Okay. Okay.
I'm gonna stop the share.
Okay.
Okay, I'm just gonna share the screen again to make sure that everyone has understood. Okay. This is the test. This is the first page of the material, and you have it as PDF. This is the first exercise of the test, page 2 of the PDF. Page 3 of the PDF, still the test. Page 4 of the PDF, still the test. And last page of the test is page 5 of the PDF.
Decide which sentence use the correct preposition. Write your answer in the below box. There is an example for the beginning. Contra must be contrary to.
Giulio, do you think you can mute yourself because we can hear you with the answers and questions?
Sorry.
It's okay, don't worry.
Sudden noise. I would say that's about enough time. Have most of you finished? I can't see a lot of you, but yeah. Okay. Okay, I can start to see some of you. Okay, obviously this test was an informal test. It was for you to check what you remember, etc. So this is not a formal test. We're not taking in your work and checking it. So we'll go through the answers now online. So you can check and tell us how it was, if it was a disaster or a marvel. We hope a marvel. Okay. So I will start, I think Julia and I will take it a page at a time. I hope you can all hear me. If you can't hear me, you can write a message, okay, and I'll check the answers there. We'll be starting with the page that starts with the exercise where you had to correct the English. So the page where the example was, the telephone company employs thousands of staffs. Red pen ready, Guido. Sure, it's not necessary.
Absolutely.
Lovely. Okay. What I will do perhaps is just, if there is trouble and people can't hear me, I'll perhaps make a quick note of the answer also on the chat. Okay. So if you're all with me on the right page, okay, instead of asking you at this point, I will tell you the answers, okay? So number 1, your skills are the things that you can do good. The mistake was good. Okay, the answer was good. And it should be well.
Well,
Okay, you need the adverb, not the adjective. Okay, number 2, your employer did not make the correct procedure when he dismissed you. Make should be circled as it's the incorrect language. Probably better to use something like follow. Okay. Number 3, could you please confirm me that you agree to pay my client for his work? You should circle the word me because it's not necessary. Okay, simply confirm. Number 4, you should again circle me. Okay, because you either have the phrase Marco explained at our meeting or he explained to me. Okay, so you circle me, that's the mistake. And number 5, you should circle the word about. In English, you don't need a preposition after discuss. You simply discuss what. Okay. How's it going? Guido, did you use your red pen? I can't see you, but okay. The next exercise was vocabulary, and obviously I will write the words here just to check your spelling as well. Okay. Orange, an orange pen. Okay. Dismissing an employee for gross misconduct. Gross misconduct is behaviour that is completely unacceptable. When an employee is guilty of gross misconduct, the law does not expect an employer to tolerate it. The employer can usually dismiss the employee without giving him or her any warning. A lawyer would describe this as dismissing the employee without notice. Yeah, good. Okay, I can see some of you mouthing the word. I can see Luigi saying notice. Okay, when an employee is dismissed on the grounds, plural obviously, of gross misconduct, he or she might file a claim. Okay. Against the employer in a special court called an employment tribunal. The tribunal will take several factors into account. That's a very legalese word in reality. In normal English, things. In legalese, factors. Okay, when deciding if the employer acted fairly. One of the most important things that an employer must do is make sure that the correct disciplinary, check the spelling, procedure is followed. Even in cases of very serious misconduct, the employer should, 1, inform the employee in what? In writing. Okay, Sabrina answered. Okay, in writing what the problem is, as well as speaking to him or her about it. This normally takes the form of a letter. Allow the employee a face-to-face meeting to discuss the misconduct. The employee must tell the employee that he or she is entitled to have a trade union. Good, okay, you're all answering before me, that's great. A trade union representative or some other witness present at that meeting. Allow the employee to go. Okay, yeah. This is great, you can do the answers. Okay, so not act, but appeal. Okay, against the decision. Employees must follow these rules. It's very dangerous to dismiss an employee on the spot. On the spot. Okay, and the last one, the employee will almost certainly, I see a lot of you have written it already, sue for damages, and he or she is very likely to win. Okay, so I started to read your answers that you were typing. They looked pretty good. I saw 1 or 2 little mistakes, but I think in that 10 questions, I would expect a minimum of 7 correct. No? Okay, Julia, do you want to take them through the next page?
Yes, absolutely. Right, so we are on where... Sorry, Coralba?
Not seek.
No, not seek, not seek.
Oh,
No.
instead of sue, seek in damages, no?
Sue for damages.
No, no, because of the preposition. Okay.
Okay.
Don't speak for is wrong.
Okay.
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 So even grammatically it was wrong. So you sue somebody for something.
Okay.
The next page is the one from the employment contract with the vocabulary.
Right, okay. What I'm going to do, I'm just going to read through, I'm not going to read the whole text, I'll just give you the answers so that we do this a little bit, you know, don't waste too much time. So bad or unacceptable behavior is the letter I. Tell or reveal, J. Not G, J. Thank you, Alvise. End, H. The duties and conditions contained in a contract, B. To have the right to something, D. A person or company who signs a contract, A. A period of time a person is away from the place they are expected to be, E. Money that a person receives after he or she stops working, G. To give because you choose to give and not because you must, F. And payment, C. Okay? Okay. Lou?
Yeah, just writing those down to check so everybody can. Okay, I, J, A, B, D, A, E, G, S, E. Okay, that's the order of the answers for anybody who didn't hear properly. Okay. Okay, the next page I have in front of me is the one, it says at the top of the page, exercise 3, which is the vocabulary one with the phrases to complete, okay? So the boy is only 14 years old, so according to English law, he does not have, does somebody want to type the answer quickly?
Yeah. Good,
Oops.
Mariangela.
Sorry, I've done it in capital letters, sorry. Capacity. Okay, capacity to contract. When the parties to a contract exchange consideration, they must gain a benefit or suffer a, detriment. If you can all read the answers, if they're wrong, I will tell you, otherwise I will leave them. Good, okay. Number 3, the of Peter's employment contract is 6 months. Term is correct. Number 4, a person age is one important factor. Okay, right, I'm waiting for the answers because otherwise we'll get confused. So number 4, factor. Number 5, in the UK, common law says that the acceptance of an offer, okay, so number 5, offer. Number 6, in England, a promise of making a donation or giving someone a gift is not usually enforceable. Number 7, in some countries, is it possible for one party to liability? Good, great. Number 8, to give your consent. Okay, on to number 9. There is something between Mr. Green and Mr. Cox, dispute. And finally, number 10, my client claims that, at this point, there's one word left, sum of £5,000 in damages. Good. Right, is the second is detriment.
Because I haven't put it in.
Just you were given that choice. You can suffer a loss, you can suffer a detriment. Okay, you didn't have the word, Los was already used in the example, simply for that reason. Okay.
Right, and the next exercise is where it says exercise 1 on where it says look at the group of words. Okay, so in each... Who said something? Did somebody say something? No, did you say something, Stefano? Okay, right. Okay, so the group of words, 3 words belong to the same area, 1 doesn't. Okay.
Sto seguendo la lezione di Legal English.
I'm sorry, Stefan, I couldn't hear what you said. Can you say it again for me?
I think perhaps he had his microphone on by mistake.
Okay, that's fine. Right, okay. Sorry, didn't hear what you said. Such a problem. Right, okay. Number 1, the word you should have circled was statute. Yes, good. D, very good. In number 2, the word you should have circled was C. Good, excellent. In number 3, the word you should have circled was B. Fantastic. Number 4, you should have circled D. Good. And number 5, you should have circled D. Excellent. Good. Well done, Mariangela and Manuela. Excellent. Good, good, good. And the prepositions, which Louise and I both love. And Eric will remember that I used to love teaching about prepositions, and I do break the proverbial about them. Right, number 1, your answer should have been A. Number 2, B. Number 3, B. Number 4, A. And number 5, B. Good, excellent, well done, everybody. Okay, that's really good. Okay, Louise, do you want to open your mic, my love?
Hi.
Hi. Right, so that brings us to the end of the test, doesn't it?
Yeah.
I think. Yeah, okay. So everybody, did that go okay? Any particular disasters? Write on the chat. Yes, that went okay. Mariangela, good. Okay.
Sorry.
Not so bad. Okay. Good. Okay. Fantastic.
Person who was using the red pen or the orange pen, how was that? I think that was Guido.
That was Guido, wasn't it? Yeah.
Okay, good, okay. There's lots of okays.
Good, good, good. Right. I think we will begin.
What we should be moving on to the law of tort. Okay, so I don't know how your PDF files have arrived, but this is what we should be working on next. Okay, on the law of torts.
Yeah,
so
this should be the first page. I don't know if you can see where it says the law of tort.
Okay. Alvise, sometimes I am in Stefano's
yeah, Alvise, social distancing.
Where is Alvise? I don't understand. Hang on. No. Ah, okay. Right. Both Julia and I as well, and I'm sure all of you would like to have a break at some point. This is not only because you need a break from English and from the lesson, but in particular because of screen time. So we do suggest to all of you when we do have a break, which if that's okay with you, at about 11:30, for you to remove yourselves from your computers and go for a little walk around the house and get away from your screens, because we're living our lives on screens at the moment, except for Avvocato Daniele, who looks like he's in the Caribbean.
Hey, that was actually.
Daniela, you have a fantastic background behind you. I love this.
It's pretty good, isn't it?
In a dream world.
Right. Are you going to do your story on taught? I think you should. It'll cheer everybody up.
Oh no, Julia.
Oh yeah. I think you should.
Oh
Go
no.
on, make it.
So when I first started learning about the law of tort, I'm very sorry, but I made a terrible, terrible joke in English about this. Okay, and it's not correct. I'm being recorded, Julia. You shouldn't make me say these.
Well, it's okay. Don't worry. Remember what I said last lesson that was broadcast to 4 different cities. So
I hope none of you are offended by this silly little play on words, but I suggested that a lady of the night, okay, in English, a lady of the night is also known as a tart, T-A-R-T. And I suggested that if a lady of the night trips on the street when she's working at night, then she suffers tort, and she is a tart with tort. Sorry. Sorry.
oh,
Terrible, terrible joke.
that's brilliant. I'm sorry. I absolutely love that.
Julia likes it.
I do like it. I do like it. I'm sorry. But okay, so looking at the law of tort. Okay, now the first page is just giving us some basic information about it. What we'd like you to do is read through the text, okay? And we've got 5 sentences which are true and false. So we'd like you to read through, say if they're true and false, but also underline in the text where you find the information, if it says true or false. Okay.
There is, as usual on this course, a lot of reading to do. That's where we find all the vocabulary. So there is a lot of reading to do. Occasionally, if you're happy with it, we will read something out loud just so you can hear our beautiful pronunciation. And occasionally, it's easier if you just read to yourselves. Okay.
Just write on the chat what they're doing.
Yeah.
Oh, I'm writing it in capital letters.
Can I just make a quick suggestion? This is what most of my Zoom classes are doing. Could you just write finished or fin or something on the chat when you finish, so that when we can see that a large number of you have finished, we can check together. just give you 1 more minute for the last people to complete the exercise. We'll check. I think, again, it's very difficult to see when a lot of you don't have video cameras and I can just see your names, because it's easy to see when somebody's finished when they start to play with their pen or something. Okay, but the ones who are just names on the screen, it's very difficult to know what you are doing. Probably having a nice cup of coffee. Okay, so the law of tort aims to compensate people for different types of harm and not just physical harm. You should have said that that is true. Okay, it's true. Okay, it could be the loss of money or something like that too. Okay, B, I must have a contract with someone to make a claim against that person under the law of tort is false. Okay. I may be liable to compensate him or her for that harm, even in situations when I do not have a contract with that person. Good. Okay, C, I can only make a claim against someone under the law of tort if that person hurt me intentionally. That is also false. Okay. D, the main purpose of the law of tort is to punish people who cause harm to others. That is also false, okay? It's to compensate people who suffer harm as well. Okay, and I can be liable for my actions under the law of tort to someone who was a complete stranger to me. That is true. Okay, so the answers are true, false, 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 true. Okay. Should be relatively simple, I think, at the beginning of the exercise. Okay, the next exercise, we're just following on in a logical order. I hope that your PDF files are also in a logical order. I don't know. But the exercise 2 that follows is simply completing the phrases with vocabulary from the previous exercise. Okay, so it says exercise 2, use the correct words from the key vocabulary to complete the following sentences. So that literally is 1 minute work, okay? So use the vocabulary, complete the phrases A to E, okay? And we'll check. 1 minute. Ready, steady, go. Mariangela is checking that it was false and true finally. Yes, it was. The loser will offer a pizza.
But is that a pizza to absolutely everyone in 4 different or just we'll have runner pizza all over the country. Okay.
Yeah, I can't get pizza in Rufina at the moment in this period. I have to make it myself.
Right, you want to check the answers, dearest?
Sure. Okay, so phrase A, the word that was missing. Who ran out of money? Massimiliano.
Yeah. I know where we know the feeling. Trust us, we know the feeling.
Yeah, this is why I'm making pizzas at the moment. Maybe I should sell them in Rufina. Okay, so phrase A, you should have simply the word compensate. Okay, good. Oh, good. Manuela can write the answers. That's much easier for me. Thank you. I'm slow at typing. Phrase B, you should have liable. Great. Phrase C, intention. Correct. Phrase D, good, okay. Just occasionally I see people spell this word incorrectly. I don't know why, but that's fine. Good. And finally, the word damage. Damage, okay. What's wrong, Manuela? No, negligence. Okay. So the word damage means the same as the word harm, but that is quite important. The word damages is not the plural of this word. So damage as harm is uncountable. Okay, so the wind doesn't do damages to a house, it does damage, while damages as compensation is countable. I probably mentioned that before. a little obsessive with capitals and underlines.
We did that last lesson as well.
Yeah,
We went over
yeah,
that.
I think so. Okay, good, no problem.
Good.
Manuela, you're saying no. Did you get one wrong, Manuela? Did you? No.
Manuela so far is offering the pizza then to everybody.
Okay, over to you, Jane. Julia. Microphone. Microphone.
Sorry. I've done it. Okay. I occasionally mute myself, which is very strange for me because I never mute. Right, exercise 3. Now, I think you probably know what a bit of a stickler I am about full grammatically correct sentences. Those who have been my student in the past, or that person, knows exactly what I mean. Exercise 3. Read through the text and look at the sentences or the questions underneath A to F. You're going to write full grammatically correct sentences, okay? So it's important that your subjects and the verbs, everything is in the correct order. Okay, this shouldn't take you too long because the text is quite short. I'll give you about 8 minutes, okay?
8 minutes, very precise there, Mrs. Julia.
Yeah, that was very precise. I admit it was precise. So
obviously, so with the first one, what is a tort? A tort is not just a short answer. Categories, yeah. We, you, lawyers.
Not English teachers, lawyers.
Responsabilità.
Are done, so I think we'll start. Yes, Lou?
Yeah, I'm just going to mute my microphone because if you're going to ask people to answer vocally, I'll switch my microphone off.
Okay, right. Okay, so I'm going to pick at random. I'm going to be particularly horrible and ask one of you to answer the question. So, who have I got on my screen now? Let's see. Pick somebody at random. Alvise, microphone on. You can. Okay, perfect. Alvise, what is a tort? Yeah, telephone. I'm like, how is it possible? The one person I asked is on the phone. Right. Eric, I'll ask you. You can't get this wrong.
Cleo.
Eric, what is a tort?
A tort is a conduct that causes harm to another person.
Good. Excellent. Good. Perfect answer. Lovely. Thank you. Okay. Let me see. David, what are heads of tort?
Heads of tort are categories of tort.
Yeah, add a little bit more information.
Different types of tort, different types of categories.
Okay, different categories of tort that exist in English law. The important bit was that little bit there. So the correct answer would be is the heads of tort are the different categories of tort that exist in English law. Okay. Okay. Manuela, C, what does to bring an action in tort mean?
To bring an action means to sue a person for having suffered an harm, for suffering an harm, something like that.
Okay. You sue someone on the grounds.
On the ground,
that,
yeah.
Yeah, on the grounds that you suffer harm. Okay, suffer harm. Good. Okay. Barbara, what is a remedy?
A remedy is something that compensates me from my loss, or that stops me, or that stops the harm from happening again.
Good. Excellent. Very, very good. Okay. Stefano, what is the usual remedy for a tort? Stefano? Not there? Not there. Okay, good. Stefano, E. Tell me the answer.
Damages. It's damages.
Yeah, can you give me the full answer though?
The usual remedy for a tort is damages. Damages.
Okay. Yep, perfect, good, okay. Alvise, you're back. Okay, so let's have F. Alvise, what name do lawyers give to the person who commits a tort? Yeah, okay. It was supposed to be a full grammatically correct sentence. One word, probably not the best answer. The answer to F was lawyers give the name tortfeasor to the person who commits a tort. So tortfeasor is the correct answer, but we wanted a full grammatically correct answer. But okay, not bad at all. Now, the next exercise is one of my favorites, as I've already said, prepositions. So we're on the part where it says types of tort, which is page 3. It says types of tort exercise 1. Okay, we're looking at the different types of tort that exist. Just quickly read through it and decide which is the correct preposition. Okay, give just a couple of minutes to do this. It shouldn't take too long. This one has been done for you. There are several heads of tort in English law. The most important heads are negligence, trespass to land, nuisance, trespass to the person, and defamation. We will look at the nature of these torts in exercises 3 and 4 below. To trespass is a general word that means to interfere with. Good. Interfere with something or someone, or to do something that causes harm. If I want to bring an action, good, against a tortfeasor, that person's conduct must usually fit, good, into one of the heads. However, some areas of tort are constantly developing. As society changes, the conduct we regard as unacceptable or harmful changes too. Lawyers usually divide the heads into 2 categories. These are torts that cause harm to people and torts that cause harm to land. Good, very good, everybody. Well done. Excellent. Good, good, good.
And then it was with, against, into, as, into. Okay. Julia, we have totally different pronunciation. Isn't that funny? You say trespass and I say trespass. That's because I'm from the north.
And I'm from the south.
So just very, very quickly, the exercise under exercise 2 is vocabulary. Exercise 3, I'm going to read through with you for a change. Okay, but first look at exercise 2. Okay, what does the verb to trespass mean? What are the 2 types of trespass? Does the law of tort always stay exactly the same? And what 2 categories do lawyers usually divide the heads of tort into? I'm not worried about full phrases on this one. This is not a obligatory in this one. I just want a quick answer. So, what does the verb to trespass mean? Does somebody want to use their microphone or write the answer? To trespass means?
Trespass means to interfere with something or someone.
Exactly. Okay, so not only with a person, but also with land or something like that. Correct. Okay, the two types of trespass are? Somebody? Either with the microphone or writing, I don't mind. Trespass to land and?
Or the person.
To the
yeah.
person. Good. Okay, trespass to the land, trespass to the person. Okay, does the law of tort always stay exactly the same? It's a nice short answer. No. That's your answer. No, it doesn't. Okay, and the two categories that lawyers usually divide the heads of tort into are? Similar answer as to B. Harm to people, harm to land. Okay, good. No problem there. Right. You happy to listen to my lovely voice for a little minute or two? Okay. Because the next exercise...
They're not say no, are they? That would be rude to say.
Say no, we hate your voice. I'm going to read through the three main torts, okay? You have the vocabulary, the key vocabulary, as usual, which the key words are assault, battery, defamation, libel, false imprisonment, slander, negligence, duty of care, trespass to the person, okay? I'm going to read through the torts, and then after we have some little situations about various people, and we have to decide which tort, what was the problem, okay? So the three main torts that cause harm to people. The first is trespass to the person. It means to harm someone in a physical way. To make someone afraid that I will physically hurt them is the tort of assault. To actually hurt someone in a physical way is the tort of battery. This was actually new to both Julia and I, because I think in general English, confirm this if you think it's true, Julia, in general English, to assault someone is to hit them in some way, but in legal English, no. Do you agree?
Yeah, yeah.
Okay, but in this case, no. If someone is afraid that you'll physically hurt them, that is assault. To actually hurt someone is battery. Okay. Keep someone in a certain place without that person's permission is the tort of false imprisonment. All of these torts are known as trespass to the person. Then we have defamation, another category. Defamation occurs when someone makes a negative statement about another person which harms that person's reputation. In other words, it means saying or writing something negative about someone so that other people think in a more negative way about that person. So there are two forms of defamation. The tort of libel is publishing the statement in a permanent form. For example, writing it in a book. The tort of slander refers to a statement in a form that is not permanent. So, for example, saying something in an ordinary conversation. Okay, and then finally, negligence. Negligence occurs when you cause harm to another person because you were not careful enough. The law of tort says that in situations where you can anticipate that your conduct is likely to cause harm to another person, then you have a duty to be careful. Lawyers refer to this duty as the duty of care. Negligence is the most common ground for claimants bringing an action in tort. Okay, so underneath you have the little situations, and each situation has a space in it. Okay, so can you complete the spaces with the correct word, and then we'll check together. Okay.
I got clicked out.
Yes, Julia, you've changed position. You were standing next to me.
I got clicked out of the conversation.
I'm sorry.
I don't know why.
So let's just check these little situations, and then I'll tell you, I'll take you briefly through exercise 4, and after that we will have a break before we move on to the duty of care. Okay, so Julia runs a cafe in the town centre. Last week, one of her customers burnt his hand when he touched a very hot plate. She didn't warn the customer that the plate was hot. He claims that she was not careful enough and that he will sue her on the grounds of negligence. Okay, lovely. Her solicitor explained to her that as the owner of a cafe, she has a duty of care. I love this. I'm getting other people to write all the answers. It's wonderful. Okay. She has a duty of care to all of her customers. Mary was shopping. Okay, the police discovered that Mary paid for the necklace, blah, blah, blah. Mary sued the store on the grounds of false imprisonment. Correct. Gary was playing football on Saturday. Gary shouted at his friend named Bill on the other football team. He shouted, "I'm going to kill you." This is not the tort of assault, as Bill did not really believe that Gary intended to cause him physical harm in this situation. So in this case, we need assault. Okay, I see some different answers coming in. So D equals, let me just check that that's clear. D is assault. E, last year, Paul was successful when he sued the police on the grounds of battery. Paul was taking part in a political demonstration when a policeman kicked him and pushed him. So that is actual physical assault is battery. E, correct. F, the heads of tort that include false imprisonment, assault and battery is trespass to the person. Lovely. An unrelated question related to C. Aspetta, is this also a case of false imprisonment, or can we give a different term given the police result? Given the police role, excuse me, sorry, I'm stumbling over the reading of the question here.
Just read. Unrelated question. Related to C. Is also a case of false imprisonment, or can we given the police?
I don't quite understand the...
No, I don't, because the answer is false imprisonment. So,
because she was kept in the...
She was detained for a bit. Well,
45 minutes she was contained in the shop against her will, even though she was innocent. So, yeah, it is false imprisonment. Yeah. Okay. F, I said that false imprisonment, assault and battery is trespass to the person. Not detained rather than contained.
Detained. Mm.
Yeah. The head of tort, G, that includes libel and slander is defamation. Good, okay. David Boy was at a party. David said that George was a typical thief and everyone at the party heard this. George might sue David on the grounds of, this is H, slander. Okay, so it's just speaking. And the actress, Crystal Ben, is using a major newspaper on the grounds, is suing a major newspaper on the grounds of libel. Okay.
Libel.
I think after a certain point standing in front of the screen, my eyes are starting to cross all.
Mariangela, we've just gone through the answers. Where did you lose from?
Hang on. Okay, sorry, Julia, I got clicked out of Zoom for some reason.
Who? Me again?
Me, I'm back.
Ah, okay, okay, sorry, yeah.
Okay, I've lost all of my chat as well, unfortunately. But...
Okay, now I've got the chat. So, Mariangela, the answers were, listen carefully, A, negligence, B, duty of care, C, false imprisonment, D, assault, E, battery, F, trespass to the person, G, defamation, H, slander, I, libel. Did you get that?
I'm writing them.
Okay, right.
Just writing them down.
Yeah.
Okay, in that order, they were the answers. Okay. I'm sorry, I clicked out, so I've lost all of the chat, but I presume I haven't missed anything too much. Okay. So the last little one before our break, everyone, is exercise 4 with information about torts that cause harm to land. I'm not going to read this one out loud now, obviously, because I'm asking you to try to put the words above, the key vocabulary, into the text. So you have objects, claimant, committed, enjoy, permission, factory, grounds, and walking, to attempt to put in this little article. Okay, they should be relatively logical, but we'll check together in about 3.5 minutes. Okay.
3.5. Very precise.
Exercise.
Number 1, there is no exercise 4. There isn't it?
I might share the screen.
Okay.
Yeah, do you want? Yeah, that'll be great. Thank you.
Called page 5 officially. Yeah.
Page 11, exercise 4.
Great, thank you.
Our super technological Emanuele.
Thank goodness.
I had to learn.
We've all had to learn super quick. Mariangela, have you found the right page now? No, she's still lost. Oh,
Okay, I will share it again, maybe.
Yeah.
Show it a bit. Okay, so this is the PDF file. We are at page 11 of the PDF. This is page 11. It starts with exercise 4. We're doing this exercise. And it ends before duty of care.
We've already done it. Okay, I see there's a bit of confusion, but I'll take you through this now anyway. I'll simply read it through with the correct answers in so that you can check. Okay. I think everybody's starting to get tired and beautiful word here, befuddled. Okay. So trespass to land means to go onto someone's land without that person's permission. Okay. This might mean walking. Oh, good. Somebody else is doing it. That's perfect. This might mean walking on the land, or it might mean staying there permanently. Trespass to land also includes placing objects on another person's land without that person's permission. That's fine. Good. Nuisance. Love this word. Means to interfere with a person's enjoyment of his or her own land. This means that every individual has a right to enjoy being in his or her own home or on his or her own land without anyone spoiling that experience. Claimants who might not be successful in an action for trespass to land often use this tort as a basis for legal action. Let's say I have some beautiful trees in my garden. Near my house is a small factory, perfect, involved in a manufacturing activity that uses strong chemicals. These chemicals smell very bad, but in addition to this, the fumes from the I disappeared.
Sorry, I'm sorry. I keep getting clicked out. I apologise to
No,
everybody.
me too.
Okay.
I disappeared too. Okay, I don't know where I've lost the chat again, but F was factory.
Okay, yeah. Okay, thank you. Right. Okay, so lots of people got crashed out as well. Okay, we'll just quickly go through the answers again to this. So A is, I've lost it.
Permission.
A is permission. B is
walking.
Sorry, walking.
C objects.
Good.
D enjoy.
E claimants. F factory. G committed. H grounds. Okay. Did everybody get that, or would you like us to repeat them? Are we all okay? Yeah? Okay. If nobody has any objections, as we said, we'll have a break now. It's 11:30. Back here at around about 11:45, 10 to 12. Okay?
Okay. Okay, go away from your screens. Don't sit and do legal work. Go away. Breathe some fresh air.
Is that Arturo? Okay, now Louise has got a bit of problems with her computer, so I will try and continue the lesson without her. Right, okay, are we all back? Give me an okay on the chat if you are all back. Okay. Right, I'm going to say that that's everybody. Arturo, can you please not touch my papers? Thank you. Right, okay, we are on the duty of care, okay? which, oops, sorry, is after the exercise, after the exercise that we've just done. Apologise for my cat there. So it's after exercise 4, we're on the duty of care, where it says read the information. Do we all have that page? Yeah, page 5, thank you, Mariangela. Yes, page 5. Okay, I'm just going to start reading for you. I've also lost page 6. Give me 1 second. My cat has destroyed my papers there. Okay. So we're going to read the information and then just do 2 exercises on this. So in the UK and the USA, most cases in tort are based upon the tort of negligence. In order to bring a successful claim against someone for negligence, the claimant must prove that the defendant was in breach of his or her duty of care. The duty of care is the duty to make sure that my conduct does not harm anyone. However, the law is a little more complicated than that. The law of tort says, for example, that I am liable for the things that I do and also the things I don't do. In other words, I can be liable for harming another person because of my actions, and I can also be liable because I failed to do something that a reasonable person would do under the circumstances. A lawyer says that I am liable for my acts and also for my omissions. Omissions are the things I do not do. For example, when doctors give patients medicines to treat an illness and that medicine is dangerous if people drink alcohol at the same time, the doctors must warn their patients. If the doctors do not warn the patients, then the doctors omit to tell the patients something important, and that omission can cause harm to the patients. Both statute and common law contain rules about the situations in which people are liable for their acts and their omissions. Do I have a duty of care to everyone under all circumstances? The answer to this is no. It is an established common law principle that I am only liable in certain situations. The main limit upon my liability, we're on page 6, liability to others, is that the harm I cause to another person must be reasonably foreseeable. Foreseeable means that the results of my conduct are predictable. For example, a gas company is doing some work in the street. The men doing the work dig a deep hole. The men then go home at the end of the day. They do not put a sign anywhere to warn people that the hole is there, and they do not provide a light. A man falls into the hole at nighttime and breaks his leg. Was the result of the gas company's omission reasonably foreseeable? The answer to this is yes. A reasonable person can anticipate the results of conduct such as this. How do we know if something is reasonably foreseeable? The test is objective and not subjective. It does not really matter what the defendant says that he or she was thinking at the time of the harmful conduct. The common law provides many principles that come from hundreds of cases about what is foreseeable and what is not foreseeable. All of these factors must be considered when we ask the question, is the defendant in the breach of duty of care? Okay, good. Welcome back, Lou. Nice to know she's back with us. Okay, so the exercise underneath, okay, you have letters A to H. Look at the word and I'd like you to find the definition underneath, okay? So for example, negligence is, and then you look at 1 to 8 and write the number, okay? I think we will check. So the first one, negligence is, who's going to tell me?
You can just give a number.
Just give a number. Okay. Number 5. Okay. Number 5. Good. Number 5 is the answer. Not being careful enough. It is similar in meaning to carelessness. Carelessness, which is a terrible word to pronounce. The duty of care is good. Number 6. Yeah, the duty not to harm other people. Acts are good. Number 3, things I actively do. Omissions are good, things that I do not do. To omit to do something means good, not to do that particular thing, number 1. Reasonably foreseeable means good. Number 2, predictable, something that I anticipate might happen as a result of my conduct. Objective means good. Number 7, not influenced by your own feelings when you have to decide something. And the last one, subjective. Number 4, good. Okay, influenced by your own personal feelings and opinions. Excellent. Okay. And now we have again a true and false that is talking about what we've just read. Okay, so read very quickly to yourselves the text and decide if it's true or false. I think most people are done. And Mariangela's back again. Right, okay. Mariangela, we've just read the text on, I've lost my page now, I'm sorry, got a bit confused. Right, we've just read about negligence. Okay, true, thank you, duty of care, sorry, yes. My pages are mixed up.
Yeah, my pages are mixed up.
I've gone from 5, 6 to all over the place. So I think we'll check. Okay, so A, negligence is the tort that most legal action under the law of tort is based upon. What do we have? True or false? Good, true, excellent. I am not liable for omissions under the law of tort. True or false?
False.
Good, false, excellent. All the rules about liability under the law of tort come from the common law. Okay, false, good. I do not owe a duty of care to everyone under all circumstances. Good, true. And the defendant can always escape liability by saying that he did not personally foresee the harm that the claimant suffered. False, good, well done. It's definitely a battle now between Stefania, Manuela and Mariangela. It's a definite competition between them.
Either that or some lawyers are just lazy and want somebody else to do the work for them.
That is possible. That is possible. Right, but we won't say that, will we? Now then,
you have prepositions next.
Do we?
We have prepositions.
Oh, we do, look. Got so excited there. Oh. Okay, so.
Look how happy my colleague is. She sees the word prepositions and starts to smile.
I do love a preposition. Okay, so this time they've given you no choice. It's up to you to decide the correct preposition to go into the sentences, okay? I will give you a little bit of a help here that in sentence number 1, there are a choice of 2 prepositions that you could put in, okay? So we're on exercise 3. It's page 7 of the exercise, the PDF thingy, and where it says complete the following sentences with the correct prepositions.
There's one preposition I prefer for the first one, though.
Hmm?
I prefer one preposition
Yeah, so,
for the
yeah.
first one. I don't know if it's the same one that you prefer.
Yeah, I think it is. Is that a general yes?
I can see a few.
Okay, Coralba, thank you. Done. Okay, I'm going to say that yes, we're done. Okay. A, in the UK, the majority of cases are based. Okay, right. Okay, good for both of you. So upon or on. Louise, which do you prefer?
On.
Hmm? On?
Yeah.
Yeah, yeah. Okay. More commonly sounding is on. We would probably say based on, but it's not wrong to say based upon. B, I am bringing a claim against my doctor. Good. For negligence. Good. An omission is a failure to do what a reasonable person would do. Good. Under the same circumstances, I am only liable for breaching my duty of care to people in certain situations. The test to decide if something is reasonably foreseeable or is not an objective test, which means it does not matter what the defendant was thinking. Yeah, at the time when he or she caused the harm. Yeah, I will open a little parenthesis here about phrasal verbs. I mean, we've done, what, 3 lessons, I think, now. You should have quite a big list of phrasal verbs written down somewhere, because you're going to see them time and time again. So as you go on, and also in your future of learning, continuing to learn English, especially legal English, write a note of the phrasal verbs, okay? We've always said that in general, phrasal verbs are informal. We use them in informal language. However, the exception to this is legal English, where phrasal verbs are used a lot, okay? So I hope that you are making a note of them somewhere on your phones, iPads, pieces of paper, bigliettini, I don't know, but do make sure that you have a lovely long list of them, because you don't know, but maybe when we do the end of course test, I might throw in a very big exercise on phrasal verbs and prepositions. So be warned, I am telling you that in the foreseeable future, there is going to be a test on phrasal verbs. Chiudo il parentesi.
It's a very
Louise.
big parenthesis.
It was a very big parenthesis. I apologize. Louise, it's over to you, my love.
It's over to me again. Right, because the rest of the lesson on taught finishes with 2 relatively long texts. The first one about negligence, I will read out loud because it's a simple definition of vocabulary exercise. The final exercise at the end, we will ask you to read to yourself because it talks about a famous case about McDonald's. And that's something that you need to read for yourselves. Yeah. So I'll take you through this extra information about negligence. We'll have a quick look together at the vocabulary and the meaning of the vocabulary. So the key vocabulary we have: deterrent, redress, remote damage, proof of damage, actionable per se, negligent conduct, compensation and damages. Okay, and if you're happy to follow, I will read it out loud. So the rules in the law of tort concerning negligence aim to compensate anyone who suffers harm. However, these rules have another purpose. They aim to act as a deterrent against negligent conduct. A deterrent is something that persuades a person not to behave in a particular way. For example, the idea of prison may act as a deterrent to a person who is considering committing a criminal act. The principles of the tort of negligence are designed to act as a deterrent against negligent conduct. Negligent conduct is behaviour that might lead to harm. However, when a person is guilty of negligent conduct, then it may be necessary to make a claim against that person. A court will look at the evidence and decide if the claimant is entitled to redress. The verb to redress means to correct something that is unfair, usually by putting the claimant back in the position that he or she was in before the negligent conduct happened. The noun redress has a very similar meaning to compensation. Redress usually takes the form of damages. Lawyers often talk about being entitled to redress. This means being entitled to receive compensation or damages. Lawyers do not say entitled to a redress. Okay, so no article there. As we already know, a court first of all considers whether or not the defendant owed a duty of care to the claimant. If there is no duty of care, then there is no claim. Then the court considers whether or not that duty of care was breached. If there was a breach, was the harm that the claimant suffered reasonably foreseeable? If the harm was not reasonably foreseeable, then a lawyer will describe it as remote damage. The claimant is not usually entitled to redress for remote damage. Some torts require proof of damage. In other words, the claimant must prove that the defendant's conduct caused harm. However, some torts, such as libel, are actionable per se. If conduct is actionable per se, it means that the claimant does not need to provide proof of damage. The phrase per se is Latin. I think you might have known that already. In English, per se means by itself. The fact that the defendant committed the tort is enough for the claimant to be entitled to redress. Okay, the questions are at this point relatively simple. You're just given the question, what is a deterrent? What is negligent conduct? And you're given the answers underneath. I think about 2 minutes maximum to do that activity, please, and then we'll quickly check together. When you're ready, we'll go through it quickly. What is a deterrent then? The definition is number what? I don't have an answer C. I have answers 1, 2, 3, 4, 5, or 6. Okay, good. A deterrent is answer 4, or something that's designed to make people not do a particular thing. Okay, negligent conduct is number 5. That's correct. Yeah, careless behavior that's likely to cause harm. Redress. Okay, the same as compensation. It said it nice and clearly in the article. Remote damage was 6. Yeah, the damage that the defendant could not reasonably foresee. Proof of damage. 3, great evidence that the claimant actually suffered real harm. And finally, at this point, what does it mean if something is actionable per se? You only have 1 number left, 2. Okay, perfect. Over to Shiny Julia.
Shiny Julia, gosh.
You have the sun behind you.
No, I feel very, actually I've got a very warm face actually. I feel very good. I might get a bit of a suntan just on my face.
Vitamin D.
What? Huh?
Vitamin D.
Very good for my body, very good for my body indeed. Right, now, a famous case in English law. This always makes me giggle because of your reaction when you read the first 2 lines. I'm just going to read it out to you, and I want your reaction to this. So, this is called the McLiable case. And on February the 15th, 2005, the longest case in English legal history came to an end. The case lasted for an amazing 9 years and 6 months. Now you're probably all going to start giggling now and say, well, 9 years isn't really that long in Italian legal history. Am I right? Yes, I'm right. Thank you, Filippo, for the sunny Julia. Thank you, I appreciate that. Yes, Mariangela, quite right. For you, it is probably quite normal that something would last 9 years. In English law, obviously not. So it was the longest case in either criminal or civil legal history. There were 313 days of legal argument in court and 20,000 pages of court transcripts, which are the documents that record what happened in court. 130 witnesses gave oral evidence to the court. This case was based upon the law of tort. The case was famous all over the world because of the nickname that people gave to it. This nickname was the McLibel case. The claimant in the McLibel case was, of course, McDonald's, the chain of fast food restaurants. This case was so famous that the word McLibel now appears in some respected English dictionaries.
Yeah, Oxford.
I didn't know this. Yes, quite. Oxford, Cambridge, and one of the others probably. The facts of the case are as follows. The defendants in this case, Helen Steele and David Morris, belonged to a group of people who were worried about the environment and about the way that certain large corporations were behaving in relation to the environment. The group decided that the best way to tell the public about this was to give out leaflets containing information about the problem. In 1990, Helen and David stood outside several McDonald's restaurants in London. They gave leaflets to people who were in the area. The title of the leaflets was, "What's Wrong with McDonald's? Everything They Didn't Want You to Know." The problem was that the leaflets contained some very controversial claims. For example, the leaflet said that McDonald's was partly to blame for the destruction of the rainforests. It also claimed that McDonald's foods was unhealthy and eating too much of this food could give people health problems later in life. In 1990, McDonald's issued a claim against Helen and David on the grounds of libel. The company did not need proof of damage as libel is actionable per se. The libel trial started in 1994. There was no judgment until 3 years later. Helen and David were found to be guilty of libel. In 1999, Helen and David appealed, but again they were ordered to pay damages to McDonald's. Helen and David refused to pay the damages. They decided instead to appeal to the European Court of Human Rights in Strasbourg. 2 barristers from England represented Helen and David in Strasbourg, and the Strasbourg court made a decision that changed English law. The court decided that the English courts followed the correct procedure, but that, nevertheless, the trial in England was unfair. This was mainly because Helen and David were poor compared to a big corporation such as McDonald's, which meant that they could not pay for an expensive legal team. As a result of this, Helen and David's defense was not so well prepared. The court also ruled that Helen and David's right to free expression was violated. The court awarded Helen and David damages of nearly £47,000. Well, who knew about that? Right. The exercise underneath is not your favorite, I know. It's answering the questions about the McLibel case with a full grammatically correct sentence. All of the information is in the text which I have just read you. Definitely one of my favorite bits. Manuela in capital letters has written down. Okay. It's fine. It's okay. It's fine. It's okay. answers then. I will, you're absolutely right, Manuela. Yes, it is. If you remember modern letter writing, when I said never write in capital letters, it looks as though you're shouting at the person, underlining the fact that maybe you think they don't understand what you're talking about. So, but it's fine. Absolutely fine. Okay, now let's check the answers. I will ask you to tell me. So, I'm looking at my screen at the moment. Filippo, question A, how long did the McLiable case last?
The McLiable case lasted for 9 years and a half.
Okay, 9 years and 6
months. Yeah.
Yeah.
Much
yeah.
correct.
Okay. Good. Okay. Elisa, who was the claimant in this case?
It was McDonald's.
The claimant in the case, yes, was McDonald's. I've suddenly realized I've got two Elisas in front of me. I should have said Elisa 1 or Elisa Z. That would have been easier.
Only Elisa.
It has been lasted. No, absolutely not. Whoever. Bartolena, no, no. C, who were the two defendants in this case? Federica?
The defendants were Helen and David.
Can you say that again? I didn't hear.
The defendants were Helen and David.
Okay, Helen Steele and David Morris, because they're not married. So you need to say their surnames. Okay. What global issue were Helen and David worried about? Nicola?
Helen and David were worried about the environment. Sorry.
Okay, yeah, I'll accept that. Yeah, that's fine. How did Helen and David tell the public about their worries? Stella? No? Okay, well, I'll do that one then. So E, Helen and David told the public about their worries by giving out leaflets. Okay, I think I'll continue because it's a bit difficult to get the connection with everybody. So F, what claim did Helen and David make concerning McDonald's and the environment? Helen and David claimed that McDonald's was partly to blame for the destruction of the rainforests. G, why did McDonald's not need proof of damage? McDonald's did not need proof of damage because liable is actionable per se. H, what was the decision of the Court of First Instance? The Court of First Instance held that Helen and David were guilty of liable. I, why did the European Court decide that Helen and David's defence was not so well prepared as McDonald's claim? The European Court decided that Helen and David's defence was not so well prepared as McDonald's claim because Helen and David could not pay for an expensive legal team. And the last one, what other ruling did the European Court of Human Rights give in this case? The European Court of Human Rights also ruled that Helen and David's right to free expression was violated. Okay, did we get all that lovely and correct?
They were. You said you wanted long, grammatically correct phrases. Some of them were really, really long, weren't they?
Yeah, I know. Some of them were particularly long.
I and J in particular, yeah.
Yes, yes, definitely, and quite repetitive as well. So,
and I can't see Bartolena, but I'm sorry, Bartolena. I continued to answer your question about the grammar. I like grammar.
Okay, you can consider. I mean, do you want to, apri un parentesi here about that?
No, it was okay. I'll do a parenthesis in the next part about the passive.
Okay, now we're going to leave the law of tort and go on to something completely different. Because you know how Louise and I like to
love the law of tort.
Top and change every now and then. Must say that the time is going very, very quickly, which is, I think, quite good for most people, definitely for us. Understanding Contracts 1. It should be page 10. Emanuele, can you just share your screen with that page so everybody knows where we are?
Yes, just a second.
Thank you very much.
Icca.
Ciao Fede, come stai?
Ciao.
Tutto bene?
It's a little bit further on. Okay. Yeah, that's it. Perfect. Perfect.
I'm gonna stop the share now.
Okay. Yeah, that's great. Okay.
We wanted to start doing this part at least because in the original 8-hour lesson we intended to do parts 1 and 2 of understanding contracts. Today we won't get much more of this done, but we just wanted to start looking at the lovely language of legalese.
I will tell you that this lesson is full of vocabulary and full of words that I think you should be noting down. Okay, it's quite a full lesson of you know,
it's full of expressions that a lot of the time only lawyers or Shakespeare use, because legalese, obviously, I don't know if the term exists in Italian. I was told that legalese doesn't exist and that I had invented the word. I believe it exists, but yeah, a lot of your language is a lot heavier and more archaic than the normal English that we use. Absolutely. I have a teenager passing under me. One moment. Sorry, Julia.
Okay, it's fine. Okay, so the style of written contracts. I don't know. Shall I read or shall we let them? Does anybody want me to read, or are you happy reading to yourself? You tell us. What would you like?
I personally think it's good for Julia to read it because there are lots of little points that I know she will stop at. Okay. And also I will have a quick stop. I'll interrupt Julia when she starts talking about passive voice.
Okay, so I will read. Okay, the English of contracts. Lawyers in most countries use different and more difficult language to draft contracts from the language that they use every day. This is certainly true within the English legal system. However, when you know in what ways the language of contracts is different, you can look at the language very carefully and understand it more easily. Here is a list of what makes the English of contracts different from normal English. Oh, thank you, Bartolena. That's so sweet. Thank you. Lawyers use very long sentences when they draft contracts. A typical sentence in a contract can be 100 words or more. Right, my first open a parentesi is this. In general English, the rule is that your sentence should be no longer than 20 words. If your sentence is going to be longer than 20 words, can we please put in the punctuation, okay? Put in a comma, put in a full stop and restart the sentence again. Chiudo il parentesi. Often these very long sentences have no punctuation. This sometimes makes it difficult to understand what the sentences mean. Yes.
Italian ones are even longer.
Yes, exactly. So, lovely lawyers, punctuation. Can we please have the punctuation? Very, very important. Sometimes in contracts, sentences in contracts have an unusual structure. Sometimes legal English doesn't use words in the same way as general English. Some verbs, nouns, and adjectives are put in a sentence in a different order from normal. Yes, very true. Lawyers often use too many words. And I'm stressing that, too many words. A lawyer might use 20 words to write something that he or she could write with 5 words. Now, I'm being quite serious now. When you are writing a contract, yes, it's true that you have to obviously use the correct legal terminology. However, always think about who is going to be reading the contract. If you are writing a contract and you have to explain the contract to somebody who has absolutely no idea about the legal terminology, you're going to have to try and word it and also say it in a way that they will understand. It's very important, this. Contracts contain words that people don't use anymore because they are so old-fashioned. For example, there are words that you will find in a play like Romeo and Juliet, or in a contract, but nowhere else. You're not going to find Romeo, Romeo, where art thou for Romeo? That you're not going to find, but do check the language. Contracts also contain very formal words that no one really uses in general English. Yeah. Lawyers use long lists of synonyms in contracts. This is because when a lawyer drafts a contract, he or she thinks about the fact that a judge will interpret the contract if there is a dispute. In codified legal system, words have a clear definition. However, in the common law system, judges have interpreted words in different ways. Lawyers use lists of synonyms to make sure that there is no possibility of misinterpretation. Lawyers like to use the passive voice, and here Louise will come in. The passive is more difficult than the active. Louise.
No, I just wanted to open a little sort of bracket about the passive. So the passive form makes any article a lot more formal, but it is a lot more widely used in English than in Italian. We can use it for all the different tenses in English. For example, my car is being repaired. In Italian, you could not say la mia macchina sta essendo riparata. Clearly, it doesn't work. But we use it in all tenses. It removes the subject from the. So, for example, in a newspaper article, they will use the passive form all of the time because they don't want to specifically say who is guilty of a crime. So I just want to give you 3 or 4 very, very basic examples. I don't know if you can see my board. Hang on one moment. I don't know where to put it. Can you see that more or less, or not?
Put it down a little bit. Come a little bit closer, but down a bit.
Okay, just do the first ones.
Can't quite see it.
No, okay, I'll write them on the group instead.
Write them on the chat.
Okay,
yeah.
Qui a cucciolare. Yeah.
I'll write it on the chat instead. Okay, so for example, you have a phrase like, the man committed, what did I say? A crime. Okay, that's an active phrase and you wouldn't see it in a newspaper. Mr. Smith committed a crime. No, but you would make it passive by starting with a crime. You take the tense from the verb, so it's past simple. Be, past simple, and then the verb. A crime was committed. Okay, and I'm sure you can do this, but I just wanted to check because we can use it in all different tenses in English. You must sign the contract. Okay, the contract. Can somebody finish that in a passive for me? The contract. Writing. Yeah, okay, so the contract must be signed in all tenses. Mr. and Mrs. Smith will win the case. The case somebody complete it for me? So so will be won by. And the last little example I gave was that the case, so Mr. Brown has won the case. Somebody right? Okay, I need a present perfect of the verb be. No, in this case, has been one. Yeah, so Mr. Brown, right, yeah, has been one is correct. Yeah. Okay, Mr. Brown, one, the case was what another of you wrote. So the case was one, etc. So you just have to remember all of the different forms of the verb to be, but it is really, really important because it's used in newspaper language and in contract language and in legalese in general. The passive is adored. There you go, passive. Okay, sorry,
no, that's wonderful. Thank you, my love. Okay, right, let's just quickly finish off this. Contracts contain technical words that are part of the language of the law or part of a particular area of business. It is necessary for a lawyer to use these words. All of these things produce a style of writing that is very unusual, even to a native English speaker. The language that lawyers use in contracts is so different from general English that some people say it is not real English at all. I agree. But a language only for lawyers called legalese. There is a movement in England away from legalese. Lawyers are now encouraged to write in a more modern, understandable style called plain English. This is good news for international lawyers like yourselves. So if you are writing a contract in English, move away from the legalese type of contract and start writing using plain English. It helps you, but it also obviously helps the person that you are writing for. And don't use Google Translate because it doesn't work.
Obviously, a lot of the terminology is still a lot more formal than normal English, even in this, excuse me, even in this plain English. I mean, a lawyer will have to use particular vocabulary that is from legalese. I mean, there are certain words that you can't use otherwise, but yes.
Exactly. Right, now, the exercise underneath is the classic full sentence. However, I think we'll do this quite quickly. So just write a few words for the answers. You don't have to write full sentences, okay? So it's A to F, talking about what I have just read, okay?
Yeah, sometimes a one-word answer is okay here as well. Sorry, Julia.
No, that's fine. Sorry, what did I say?
No, I'm just saying a short answer is fine. I know you love your long answers, but
I do, but this time we'll keep it short. Using best kind regards. Okay. No kind regards, Mariangela says. Okay. Or best regards. Okay. That's a general question. In a full sentence, do we have to paraphrase the words in the main text? In these kind of exercises, yes, they do like you to, Manuela. Seems a bit repetitive, but yes, unfortunately. Right, okay, I think we'll check the answers and then move on. So, A, is the English of contracts easier or more difficult than general English? More difficult. Okay, more difficult is fine. How long can a typical sentence sometimes be in a contract written in English? 100 words or more. Do lawyers use words in the same order as in general English when they draft contracts? They use long lists of synonyms when they draft contracts. Oh no, sorry, I'm using the wrong one. Sorry, I just read the last D. Lawyers sometimes use different word order when they draft contracts. D, why do lawyers use long lists of synonyms when they draft contracts? Because they think about the fact a judge will interpret the contract if there is a dispute. E, what is the name that people give to the style of writing that lawyers use? Legalese. What is the name of the style of writing that modern lawyers are encouraged to use? Plain English. Okay, all happy about that? Okay, thank you, Mariangela. Mariangela is now teacher number 3. I've officially named her teacher 3. That's good. Okay, now, Lou, over to you, my love. We're doing exercise 2 and 3.
Yeah, we're going to fly through this as well, because I'm just taking you very, very quickly through some of the words that lawyers change from normal English to legalese. Okay, so again, you should be on page 11 at the moment, exercise 2, with words like in the event of, terminated, forthwith. I would never use that word in normal English, just wouldn't happen. Extent, okay, territory, entitled to, compensation and manner. Each one of these has a definition, but they're all words that come up in a typical contract. Okay, and they're more complicated words. So to do the following exercise, I just need to make sure that you understand these words. So an area of land, which of these words is the correct one, please? An area of land. It's quite an easy one. Territory. Okay, 5, territory. Okay, the amount or level. Okay, the amount or level is the extent, yeah. Number 4, payment for something that is lost or damaged is 7, compensation. Good, okay. To have the right to something, you are 6, entitled to something. Okay, good. Ended, yeah, terminated. It sounds so dramatic in legalese. Okay, if something happens, 1. Okay, yeah, in the event of this, immediately, forthwith. Okay, and that's the one that in particular, it's quite Shakespearean. It really is quite Shakespearean. Okay, and then the last one, the method or way of doing something is 8, the manner. Okay. I'm going to look just quickly at exercise 3. Again, this is very simple because of the language used in both, but you have extracts from contracts, and then you have the lawyer's explanation in normal English, okay, not in legalese. So quite simply, A, in the event of the death of the supplier, the rights and obligations under this agreement shall be terminated forthwith. In normal English, which of the 3 phrases underneath? It's number 3. If you die, then this contract will end immediately. Okay, it's a little brutal maybe. Perhaps that's actually nicer in legalese, perhaps. Okay. In the event that any property of the contractor is lost or damaged in the course of transportation, then the contractor shall be entitled to compensation from the company. Goes together with phrase number 1. If any of your property is lost or damaged, the company will pay. Right, nice and simple. Okay, and that means that logically at this point, the company shall allow the distributor to have full and complete control over the manner and the extent of the exploitation and advertisement of the product in the territory. Can't even breathe with the legalese phrases, okay? Goes together with 2. you will have complete control of the advertising of the product in the area of the world that we agreed. Okay, so you can see quite an enormous difference there between legalese and normal English, shall we say. And also, in fact, the next part takes you through. I don't know if you want to continue, Julia, or shall I continue?
No, you continue, lovely, you continue. It's fine.
Yeah, okay. The little formal expressions that you use all the time in legalese. So in the near future, at the present time, in the event of, during such time as, until such time as, on the part of, due to the fact that, not less than, etc., etc. I'm sorry, my telephone is ringing in the background. Okay. Julia, can you do this? I think I'm going to have...
yeah, absolutely. No, it's fine.
Sorry.
So the expressions that Louise has just read, if you turn over the page, we've now got the general English of these words. So until, if, now, by, at least, while, because, and soon. So what you're going to do is look at the phrase in legal English and find the plain English definition for it. Okay? So in the near future means, and then write it down. I'll give you just a couple of minutes to do that. A, in the near future means, somebody write it? Good, soon. Good, in the near future means soon. At the present time means, good, now. In the event of means, good, if. During such time as means, good, while. Until such time as means, good, until. On the part of means, good, by. Due to the fact that means, because, and not less than means, at least. Good. Okay, good. Well done, everybody.
The difference between them, it's very funny, I think. In the near future, soon, soon. Oh.
Okay, so exercise 2, what they're doing is they've given you formal expressions and you are going to look at the second one and make it less formal, okay? So for example, during such time as this contract is in effect, the parties agree to the following terms. Instead of using during, we would use while. While this contract is in effect, the parties agree to the following terms. So read the first sentence and make the second sentence less formal.
Through the answers then, I see lots of people have said they've finished, so I'll take you through the answers. I apologise for the interruption earlier. I have a house full of people really, all doing school. Okay, so Julia gave you the answer already to A. Answer A was while. Okay, B, in the event of breach, should be simply if there is a breach of contract. Nice normal English. Okay, this contract will continue until such time as, this contract will continue until, yeah. Okay, due to the fact that there was a fire, in reality, we could just say, because there was a fact, because there was a fire. You could also use in normal English, you could probably use as or since, both okay. Due, no, not without due to the fact. You could say due to a fire. Somebody asked a question, sorry. Due to a fire would be okay, but not just due. Due, there was a fire, no, okay. E, the meeting cannot take place on Wednesday, but it's important that we have it in the near future, should be simply soon, okay, good. We cannot consider employing any more people at the present time, simply now, good. Due to some very hard work on the part of the employees, by, lovely, and the last one, not less than 4 weeks notice, should just be at least, yeah. Okay, you can see how just changing that one little phrase to the nice simple word actually makes it a lot more legible and a lot more understandable. Presume you agree with me. Okay. Julia, you doing notwithstanding in as much as, or?
I don't mind. Do you want to toss for it? Do you want to do one and I'll do the other? I don't mind.
No, I mean, seriously, at the moment we're just taking you through the vocabulary that English lawyers use, okay? And in fact, in exercise 3, you look at 2 very important formal expressions that lawyers often use in contracts. And I can quite honestly say that as a non-lawyer, I have never used either of these words in my written English, only when teaching lawyers. The 2 words are notwithstanding and inasmuch as. And as you can see, they are both written as one word. Okay. So notwithstanding is really a synonym of despite or in spite of something. Okay, so the new law concerning the protection of the environment will come into force next year, notwithstanding a huge amount of opposition to it from industry. So even if there is a lot of opposition, despite the opposition, etc. Okay, and inasmuch as, I don't even like seeing it written like this, but it is correct in legal English. Okay, and it means that what you're saying in the rest of your sentence is true just in a limited way, or just to a certain extent. So the example they give, Caroline is a good lawyer, in as much as she usually gets a good result in court. However, she's not very good at keeping up to date with important work. So it has a limit, certainly. So we actually only have 2 choices in the next exercise. The 2 choices are in as much as and notwithstanding. Read the 4 phrases, try to understand which of the 2 terms goes in the spaces. You use 2 and 2. Okay, have a quick look at that. And they say we're trying to start using plain English, but these words are still used in contracts. As long as you understand the actual phrases, the 4 words are quite simple. Okay. 2 people have said they finished, but we'll get on with it anyway. So in phrase A, some good has come from my uncle's death. Which one of the 2 there, notwithstanding or inasmuch as? Yeah, okay. To the point that, to the extent that he left a lot of money to a children's charity in his will, but he still died. So it has a limit. Okay, B, I agree to sign this contract, notwithstanding, so in spite of the fact that I still have some doubts about your ability. Good. The 3rd one, she was employed by one of the top law firms in London, notwithstanding her lack of experience. So even though she had a lack of experience, she was employed. And the last one, the judge in the Court of Appeal held that the Court of First Instance made a mistake in as much as. Okay, it does need as well. In as much as inadmissible evidence was taken into consideration. Great, 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 great.
Okay, one thing. One thing just to note, where you find the little boxes with the help desk, do make a note of any of the words that are new or that you think you might use in the future, because they are there to help you. Okay, so just have a look at them and make a note of them if you need to. Stefania, sorry, A and B. A was in as much as, and B, notwithstanding.
Okay, Stefania.
Okay. Yeah, you're welcome. Pleasure. Okay, and what we're going to do is we're just going to go through the technical words, and then we are going to end the lesson at the end of technical words because A, it's come to the end, and B, I think everybody's stomach is rumbling because it could be time for lunch. So let's just get through technical words and then you can all pop off and have your lunch, and so will Louise and I. Right, we're on understanding technical words now, and obviously writing technical words is extremely important. And of course, you can't change these into plain English. They are as they are and have to be used in there or with all their technicality, let's say. So exercise 1, we're on understanding technical words. Hope you're all on the right page. Common words that we find in contracts. Now, these are all words that we use with buying and selling goods. So very quickly, outlet, retailer, defective, invoice, manufacturer, and sum. Can you match them to their definitions? A to F. Thank you. Manuela is done. Okay. Okay.
Sorry, Julia, I've just written the answers. We have jumped a page.
Oh, we jumped a page. Oh, I apologize.
Yeah, but it's I saw from people's faces, in fact, I think ours are probably in a different order. But what's your language?
I know, yeah, I've suddenly realised we're being recorded. I'm not saying anything that will go around the country like it did last time.
So I've just written on the chat the answers to the vocabulary on page 15. I'm sorry to confuse you, but it was just...
That's completely my fault. I took the page away and didn't turn over the page. I apologise.
Okay, so just to check that you can see that. So prior to means before. Subject to means depending on. I'm just checking that I've written it correctly here as well.
Mm-hmm.
Engaged in means involved in or doing. Inclusive of, I bet it's including. And referred to means named, called, or mentioned. Okay, so that's just quickly the answers to page 15. Sorry, Julia.
No, that's completely my fault. I apologise, everyone. And obviously, do make a note of them because they are phrasal verbs, so do make a note of them. So sorry about that, everybody. So back to the technical words. An outlet is... Anybody have that one? Yes, good. E, a shop or company through which goods are sold. Retailer. Good. D, a person or company who sells goods to the public. Defective. Yes. B, not working properly or faulty.
Like my brain at this moment.
Quite, yeah, a bit like mine as well. Invoice is, yes, C, a list of goods or services that you have received, showing how much you have to pay for them. Manufacture. Okay, good. Make or produce goods to sell. And sum is the last one. A, good. An amount. So an amount of money. Very good. Okay. So using those words, can you just pop them into the sentences underneath? Okay.
Yes or no? I know.
I think we can do the exercise 3. That'll be fun.
3 and then stop. Yeah.
It'll be fun to end.
No. Yeah.
Okay. So A, he's a successful businessman. He's got a chain of more than 20 shops in cities and towns all over the south of England, including a large, yes, outlet in London. B, have you received our? Good, invoice. C, we will have to return the computer to you because it is, yep, defective. D, Mary's renting a factory unit. She's a new business that involves the... Good. Manufacture of products for beauty salons, £20,000 is a very large, good sum to invest in new business. The supermarket chain is the biggest food retailer in the United States. Excellent. And if you turn over the page, one last exercise to end on. Anagrams, jumbled words. Now, this is where your spelling comes into notice here. So you have the definition. They've given you the first letter. Read the definition and write the correct spelling of the word.
I'm happy to see with 5 dones, that means we're done. We're ready to check. Okay, perhaps I will, I can ask you to write the words and I will just check the spelling, and if one of them is wrong, I will tell you. Okay, so first one is term, thank you, correct, correct, correct. The second one, 2 words, give, notice, correct. The third one, correct, expiration, lovely. The fourth one, correct, procurement. The fifth one, yeah, that's the correct spelling. I had my doubts actually, but aggregate, yeah, is correct. The next one is undertake, good, okay, no problems. And the last one, incur. Well, aren't you wonderful?
Okay, so lovely, lovely lawyers. Thank you. We know it's not easy doing a course or doing a lesson online, but I think we've done pretty well, I'm going to say. Not many technical problems. Hopefully next time, just one. Hopefully next time we see you all, or at least the Florentine ones, will see you directly face to face, and the rest of the ones around the cities we won't see you, but it has been nice seeing quite a few of your faces. Which is
nice to put some faces to some names.
Absolutely.
Yeah, absolutely.
You will be told, obviously, when the next 4 hours of this lesson will be. We still don't know, but obviously you will be told. And from me, that is about it. Lou, do you want to say anything?
So well done, you survived. And yeah, I look forward to the next lesson. I look forward to seeing you, as Julia said, the Florentines at least in person. If not, hey, we'll have another Zoom lesson. We managed it. Okay, so what remains to say is simply something that we can't say in English, which is buon appetito. So enjoy your lunches.
Buon appetito and see you all soon. Okay.
Yes, I want to thank both Julia and Louise for the class. We very much enjoyed it, and everyone for their attention. And I think I can say that we can end the class now.
Okay.
And so thank you very much.
You're welcome. See you all soon. Bye.
Bye-bye. Thank you.